everyone, we are group 5. My name is Sarah. My team members are Abdul Koda, Manaf Rao, Shakila Pavin, and Francis Nelly. And in today's presentation, we are going to discuss a case on Tilden Rent-A-Car Company versus Clendenning. And this is an interesting case because most often than not, in contract law, we assume that once parties come into an agreement, once parties sign an agreement, it is enforceable or it is binding. However, with this case, we realize that the court can decide to, the court can refuse to enforce laws when they realize that fairness has been compromised in instances like misrepresentation or inequality of bargaining power, or in instances such that the other party was unconscious during the time of the agreement. The court can decide to not enforce the laws of the contract. So with this case is a decision that was made in 1978 by Ontario Court of Appeal, and the name of the case is Tilden Rent-A-Car Company versus Clendenning. And the primary law of this case is contract law, non-enforcement of contract law. I'll be discussing the legal key facts that influence the court's decision on this case. So to begin with, we realize that Clendenning rented a car from Tilden Rent-A-Car Company using the standard form agreement. And this is the pre-printed contract. So this type of contract usually creates inequality in bargaining power because as the customer, you don't get to negotiate what your terms are. And usually with this type of contract, people do not read to understand before signing it. And we also realized that there was a buried exclusion clause to the contract. So inside the contract, there was a very strict exclusion clause that stated that the driver will be void of insurance coverage if he should consume any alcohol. And the rental agent did not draw his attention to it, even though he knew that there was a clause like that in the contract. And we also realized that the whole process was rushed because Clendenning wanted to sign quickly and then just get his car. And so after the accident, he was denied the insurance coverage, which is why he took the issue to Ontario Court of Appeal for judgment. So my colleagues will take it from here
Hi, I will now discuss about the legal issues of this case. The main legal issue in this case was whether the plaintiff could rely on the exclusion clause in his standard rental contract to make defendant responsible for the damage to the rental car. The fact that Clendenning paid for insurance services in addition to basic packages to get total cover for any form of accident. However, the rental agreement contained exclusion clauses in small print, in fine print. These clauses limited the coverage in certain situations, including when the driver had consumed alcohol or was involved in a criminal offense. Normally, in contract law, personally who signed a document is bound by its terms, even if they did not read it. But in this case, the court had to decide whether that rule should apply when the important terms like these conditions were hidden in standard form contract and were not clearly brought to the customer attention. This means that the key problem in this case was whether genuine consent has been achieved. To put it differently, could it be argued that defendant gave his consent when he signed? Tilden Rent-A-Car Company was required to prove that the defendant had signed while knowing all the facts. Another issue was whether the business can issue the fine print whether the business can use the fine print to remove protection customers reasonably believe they purchased. Since Clendenning or our defendant paid for extra coverage, it would be unfair for Tilden to rely on hidden terms to deny it. The main legal issue should be whether an onerous exclusion clause in a standard form contract was enforceable or not. The court balanced the rule that the signed contracts are binding against protecting customers from unfair or unexpected terms. So, the Ontario Court of Appeal decided that Tilden could not rely on the exclusion clause because it had not taken reasonable steps to bring it to Clendenning's attention. So, now my colleague will discuss about contract law principles which is related to this case. Thank you.
Hello everyone, Manav this side. Thank you Abdul for presenting your part. Now I want to talk about the legal principle in this case. It deals with the standard of contract, exclusive clauses, consents and fairness in the communication as well as transparency. The first important principle is the signed document rule. Usually, when a person signs a document or a contract, the law assumes that the person have agreed to the terms and all the conditions inside it. The rule is important because business and individual need certainty in a contract, and however, this case shows the rule is not absolute. The second principle is about exclusive clauses. The exclusive and hidden clauses in the contract terms had limit and remove one party as liability. In this case, Talent, who is a car rental company, tried to use the exclusion clauses to avoid the providing coverage and to make the another party who was Clendenning pay for the damage. The court treated these clauses as harsh and unusual because it seriously reduced the protection from the another party who had to pay for it. The third principle is the requirement for reasonable notice. When a contract contain terms that is unusual, unfair and very important, the company must take reasonable steps to bring the terms in the front of the customers. It is not enough that to hide in a small print, especially when the transaction is quite and in routine. The court recognized that in modern business, many people sign standard contract without reading even entirely. The fourth principle is the true consent. A contract is based on an agreement, but agreement must be meaningful. If one party signed the document without knowing about what is seriously hidden inside the contract and inside the agreement, the other party had to be liable for that. The court may decide that there was no real agreement in the specific term. The court applied these principles by looking at the facts, telling use a standard form of contract. The important exclusion contract which were hidden were printed in a small type and were not clearly explained. Clendenning pay a extra fee believing that he had full collision protection of the car. The clerk did not point out the exclusion clauses hidden inside the contract, even though the company knew customers usually do not read the form entirely. Because of this, the court held that the talent could not rely on the exclusion clauses. The case is important because it protects customers from hidden harsh term and reminds business that important limitation that is important, and also limitation must be clearly communicated, and the contract must be transparent. So now I'm gonna pass this presentation to my another team member. Thank you.
Hello everyone, this is Shakila and I am going to present the decision and the reason behind this decision. As you can see that the Ontario Court of Appeal ruled in favor of Clendenning. The court refused to enforce the alcohol exclusion clause. As a result, despite signing the contract, Clendenning was not bound to follow the exclusion clause. There are some reasons. Customer purchased the collision coverage. Restrictive clause like alcohol clause was not properly disclosed to the customer. But Canadian contract law requires unusual term to be highlighted to customer properly. Here we can see that Tilden was intentionally did not disclose this term to Clendenning for his unethical intention. So the key finding is here is Tilden was totally unable to prove that Clendenning was aware of that exclusion clause before signing the contract. Now I'm going to present my second slide. This slide represents important legal standard and significance of Canadian contract law. A signed standard form of contract may not be enforceable if there are 3 points. First one is there any kind of unusual term? Here the alcohol consumption term is the unusual term. Second point is the party relying upon this unusual term is totally unaware to the another party. Here the exclusion clause was not highlighted to Clendenning, and he was unaware of that clause. Thirdly, finally, reasonable notice was not provided to the customer. On the other hand, as the Clendenning didn't know about that term, and the other hand, Tilden didn't provide any kind of notice or didn't draw any attention of the Clendenning about that term. The significance of Canadian contract law is there is an exception about the traditional signature rule, where we all know that customer is bound by any kind of signature. But here the court verdicts that Clendenning is not bound by that signature. As a result, this case highlights the consumer.
Thank you for giving me a great opportunity to speak on the significance and the implication of this case between Tilden Rent-A-Car Company versus Clendenning, that was decided in 1978. This case is one of the important cases, in the Canadian contract law, because it changes a lot traditional rules, that have been in existence, that have been in existence, which stated that once person's signature is automatically signed, that the person bears the risk or bears the term of the contract, which this case led to resolving or dissolving of those issues. Now, the court recognized that many standard form, contract contains complicated terms that customers do not really understand or do not actually understand before signing it. So in this case now, the court held that when a contract is contain unusual or restrictive or unexpected terms, that the owner or the organization actually need to take time to let the client or the person to understand whatever thing is about to sign. So the decision had a very major important on contract law, because it strengthened consumer protection, because it gave them advantage. You can't expect a customer to sign something that did not really actually understand or really go through it. So that is one of the main reasons this court held in Canada made it possible that the organization need to explain it in details, and that is one of the benefit of it, which because it removed the traditional rules where we only depend on the signature and cannot be, as the person that signed it now take over it. No. So now this case continue to influence court today, especially in dispute between rental agreement, insurance, bank loan, and other this thing, customer transaction, online transaction, and so many things. So judges often rely on this principle, established in this case when deciding whether the person genuinely signed the contract or not. Now, the practical implication in this case, they have a practical implication in individual and also a practical in business. The case provide protection against hidden and unexpected clauses in terms. Then why in a business it creates a responsibility for the owner of the organization, to explain the unusual term in the contract rather than relying on the customer signature, which is very bad. Then in conclusion, the significance of this case, Tilden Rent-A-Car versus Clendenning, is that it promotes fairness, transparency, and also informed consent in contractual relationship, before anything can actually be signed. And also it remains a very trade landmark case in Canada today, yes, because it continues to guide the court in protecting consumers under unfair contract practices in signing the agreement. So this thing have also played a very important role in Canada at large in protecting consumer and giving us consumer protection. So thank you for this opportunity we had in enlightening this case, and me and my colleagues are here. If there's any question, feel free to ask us and we're ready to answer. Thank you.